starting in 5 seconds. Not for nothing, the great German thinker J.W. Goethe had said, I am what I am, so take me as I am. And similarly, Arthur S. had pronounced, no one can escape from their individuality. In this regard, it is profitable to quote a few lines from J.S. Mill, but society has now fairly got the better of individuality, and the danger which threatens human nature is not the excess but the deficiency of personal impulses and preferences. The emphasis on the unique being of an individual is the salt of his life. Denial of self-expression is inviting death. Irreplaceability of individuality and identity is grant of respect to self. This realization is one's signature and self-determined design. One defines oneself. That is the glorious form of individuality. In the present case, our deliberation and focus on the sad concept shall be from various spectrum. Shakespeare, through one of his characters in a play, says, what is in a name? That which we call a rose by any other name would smell as sweet. The sad phrase, in its basic sense, conveys that what really matters is the essential qualities of the substance and the fundamental characteristics of an entity, but not the name by which it or a person is called. Getting further deeper into the meaning, it is understood that the name may be a convenient concept for identification, but the essence behind the same is the core of identity. Without identity, the name only remains a denotative term. Therefore, the identity is pivotal to one's being. Life bestows honor on it and freedom of living as a facet of life expresses genuine desire to have it. The sad desire one is inclined to think is satisfied by the conception of constitutional recognition, and hence emphasis is laid on the identity of an individual which is conceived under the Constitution, and the sustenance of identity is the filament of life. It is equivalent to authoring one's own life script where freedom broadens every day. Identity is equivalent to divinity. The overarching ideals of individual autonomy and liberty, equality for all without discrimination of any kind, recognition of identity with dignity and privacy of human beings constitute the cardinal four corners of our monumental constitution, forming the concrete substratum of our fundamental rights. that has eluded certain sections of our society who are still living in the bondage of dogmatic norms, social exclusion, identity, seclusion, and isolation from the social mainstream are still the stark realities faced by the individuals today, and it is not only when each and every individual is liberated from the shackles of such bondage and is able to work towards full development of his personality that we can call ourselves a truly free society. The first step on the long path to acceptance of the diversity and different colors that nature has created has to be taken now by vanquishing the enemies of prejudice and injustice and undoing the wrongs done so as to make way for a progressive and inclusive realization of social and economic rights, embracing all, and to begin a dialogue for ensuring equal rights and opportunities for the less than equal sections of the society. We have to bid adieu to the perceptions, stereotypes, and prejudice deeply ingrained in the societal mindset so as to usher in inclusivity in all spheres and empower all citizens alike without any kind of alienation and discrimination. The natural identity of an individual should be treated to be absolutely essential to his being. What nature gives is natural. That is called nature within. Thus, that part of the personality of a person has to be respected and not belittled or looked upon. The said inherent nature and the associated natural impulses in that regard are to be accepted. Non-acceptance of it by any societal norm or notion and punishment by law on some obsolete idea and idealism affects the kernel of the identity of an individual. Destruction of individual identity would amount to crushing of intrinsic dignity that cumulatively encapsulated the values of privacy, choice, freedom of speech, and other expressions. It can be viewed from another angle. An individual in exercise of his choice may feel that she should be left alone, but no one, and we mean no one, should impose solitude on him or her. The eminence of identity has been clearly stated in National Legal Services Authority vs. Union of India and others, popularly known as Nalsa case, wherein the court was dwelling upon the status of identity of the transgenders. Radhakrishnan J, after referring a number of judgments and certain international covenants, opined that gender identity is one of the most fundamental aspects of life, which refers to a person's intrinsic sense of being male, female, or transgender or transsexual person. A person's sex is usually assigned at birth, but a relatively small group of persons may be born with bodies which incorporate both or certain aspects of both male and female psychology. The learned judge further observed that at times genital anatomy problems may arise in certain persons. Stop. Starting in 5 seconds. Elaborating further, he said gender identity refers to each person's deeply felt internal and individual experience of gender, which may or may not correspond with the sex assigned at birth, including the personal sense of the body, which may involve a freely chosen modification of bodily appearance or functions by medical, surgical, or other means, and other expressions of gender, including dress, speech, and mannerisms. Gender identity, therefore, refers to an individual's self identification as a man, woman, transgender, or other identified category. Going to the concept of discrimination, he stated the discrimination on the ground of sex under Articles 15 and 16 therefore includes discrimination on the ground of gender identity. The expression sex used in Articles 15 and 16 is not just limited to biological sex of male or female, but intended to include people who consider themselves to be neither male nor female. Dealing with the legality of transgender identity, Radhakrishnan J. ruled the self-identified gender can be either male or female or a third gender. Hijras are identified as persons of third gender and are not identified either as male or female. Gender identity, as already indicated, refers to a person's internal sense of being male, female, or a transgender. For example, Hijras do not identify as female because of their lack of female genitalia or lack of reproductive capability. This distinction makes them separate from both male and female genders, and they consider themselves neither man nor woman but a third gender. Shikri J, in his concurring opinion, dwelling upon the rights of transgender, laid down that gender identification is an essential component which is required for enjoying civil rights by the community. It is only with this recognition that many rights attached to the sexual recognition as third gender would be available to the said community. More meaningfully, the right to vote, the right to own property, the right to marry, the right to claim a formal identity through a passport and a ration card, a driver's license, the right to education, employment, health, and so on. Emphasizing on the aspect of human rights, he observed there seems to be no reason why a transgender must be denied of basic human rights, which includes right to life and liberty with dignity, right to privacy and freedom of expression, right to education and empowerment, right against violence, right against exploitation, and right against discrimination. The third gender. The Constitution has fulfilled its duty of providing rights to transgender. Now it is time for us to recognize this and to extend the interpret the Constitution in such a manner to ensure a dignified life for transgender people. All this can be achieved if the beginning is made with the recognition of TG as third gender. The aforesaid judgment, as is manifest, lays focus on inalienable gender identity and correctly connects with human rights and the constitutionally guaranteed right to life and liberty with dignity. It lays stress on the judicial recognition of such rights as an inextricable component of Article 21 of the Constitution and decries any discrimination as that would offend Article 14, the fons juris of our Constitution. It has to be borne in mind that search for identity as a basic human ideal has ruled the mind of every individual in many a sphere like success, fame, economic powers, political assertion, celebrity status, and social superiority, etc. But search for identity in order to have opposite space in law, sans stigmas and sans fear, has to have the freedom of expression about his her being, which is keenly associated with the constitutional concept of identity with dignity. When we talk about identity from the constitutional spectrum, it cannot be pigeonholed singularly to one's orientation that may be associated with his her birth and the feelings he she develops when he she grows up. Such a narrow perception may initially sound to subserve the purpose of justice, but on a studied scrutiny, it is soon realized that the limited recognition keeps the individual choice at bay. The question that is required to be posed here is whether sexual orientation alone is to be protected or both orientation and choice are to be accepted as long as the exercise of these rights by an individual do not affect another's choice, or to put it briefly, has the consent of the other, where dignity of both is maintained and privacy as a seminal facet of Article 21 is not dented. At the core of the concept of identity lies self-determination, realization of one's own ability, seizing the opportunities and rejection of external views with a clear conscience that is in accord with constitutional norms and values or principles that are to put in a capsule constitutionally permissible as long as it is lawful. One is entitled to determine and follow his her pattern of life, and that is where the distinction between constitutional morality and social morality or ethicality assumes a distinguished place, a different objective for the purpose of equality. Stop. Starting in 5 seconds. At the outset, we may mention that the dispute between the parties pertain to the shares of respondent number 1 Star Health Insurance Company standing in the name of the respondent numbers 3 to 7. As per the appellant plaintiffs, it is respondent number 2 which has the beneficial interest in those shares. In this behalf, the appellant's plaintiffs filed the suit through their power of attorney holder before the High Court of Madras, seeking inter alia the relief of declaration of beneficial interest of respondent number 2 herein in the shares which are in the names of respondent numbers 3 to 7. These constitute a total of 6.16% of the shareholding of respondent number 1. However, issue before this court is very limited, which pertains to the territorial jurisdiction, whether High Court of Madras has the territorial jurisdiction to entertain the suit filed by the appellants herein. As per clause 12 of the letters patent, along with the suit, the plaintiffs also filed application for seeking leave to sue on the ground that a substantial part of cause of action had arisen within its jurisdiction. This application was allowed by the High Court vide its order dated January 12, 2018. After the service of summons in that suit, respondent number 1 herein filed applications for revoking leave to institute the suit within the jurisdiction of Madras High Court on the ground that it lacked territorial jurisdiction to decide the suit. Similar applications were filed by respondent numbers 2 and 3 as well. Respondent numbers 4, 6 and 7 filed memos supporting these applications. The learned single judge of the High Court dismissed these applications, holding that High Court had the jurisdiction to entertain the suit. Appeals against this order were filed by respondent numbers 1 to 9. The division bench has allowed these appeals by the common judgment dated August 3, 2018, thereby rejecting the plaint on the ground that suit in the High Court of Madras was not maintainable due to lack of territorial jurisdiction. This order is impugned in the instant appeals. The brief facts leading to the case may be stated at this stage. It may be mentioned that only those facts which are essential to decide the controversy regarding jurisdictional issue are taken note of. Also, for the sake of clarity and convenience, the parties are addressed as plaintiffs and defendants on the basis of memo of the parties in the suit. The case of the plaintiffs was that the majority group of shareholders of defendant number 2 should have taken some steps in order to assert that it was having a beneficial interest in the share of the Indian company, though allotted in the names of defendant numbers 3 to 7. However, the majority shareholders, namely defendant numbers 3 to 7, who held 66% of the shares of the Indian company, did not take any steps, thereby causing prejudice to the Indian company. In these circumstances, the minority shareholders, namely the plaintiffs, who together hold 34% in the shares of the Indian company, initiated the suit, that is CS number 33 of 2018 in the High Court of Judicature at Madras in the nature of derivative action on behalf of the Indian company, seeking protection and declaration of its beneficial interest in the shares available with the Indian company, standing in the names of defendant numbers 3 to 7. It is the claim of the plaintiffs that even the pre-incorporation expenses of the Indian company were met by the funds remitted by defendant number 12. Defendant numbers 11 and 12 are further part of the ETA group of companies in Dubai, UAE. According to the plaintiffs, defendant number 12 had remitted a total sum of rupees 14 crores towards pre-incorporation expenses of the Indian company between April 2005 and October 2005. The same have been recorded in the books of account of defendant number 2. The plaintiffs have further claimed that 4 share certificates for a total of 33,200 shares were issued on July 11, 2005 in favor of defendant numbers 3, 5 and 7, who are shown as subscribers to the Memorandum of Association of Indian Company. The outstanding call amounts on these shares were satisfied from the remittance made in March 2006 by defendant number 12. These shares certificates are in the custody of defendant number 11 in its capacity as beneficial interest holder of defendant number 2. Defendant numbers 3, 5 and 7 have also made declarations acknowledging the beneficial interest of defendant number 2 in these shares. It was further stated that on December 21, 2005, a sum of rupees 50 lakh was remitted by the defendant number 12 through bank transfer from Masrek Bank in Dubai to the bank account of the Indian company in Andhra Bank, Chennai, main branch, and share certificates were issued in favor of the defendant number 3, which has also been recorded in the books. Stop. Starting in 5 seconds. Thereafter, on January 16, 2006, the Indian company issued payment instructions to HSBC Bank, Dubai for an amount of rupees 16 crores to be deposited in the account of the defendant number 1 in Andhra Bank, Chennai. According to the plaintiffs, contribution was towards equity share capital held by defendant numbers 3 and 4. Share certificates were also issued and recorded as having beneficial interest by the ETA group. Later, on March 6, 2006, the Indian company received further investment through 4 demand drafts amounting to rupees 3 lakhs from defendant number 12, which was recorded as beneficial interest of the defendant number 2. Defendant number 11 is in possession of these shares as well. It has been further stated that between December 2005 and March 2006, a total sum of rupees 16 crores had been received by the Indian company from defendant numbers 12 and 2 towards issue allotment of shares. On June 25, 2009, defendant number 3 issued a personal check of rupees 2 crores, which was honored on July 7, 2009 in the accounts of defendant number 2 and reflected that the investment was made in the Indian company. On June 28, 2009, a further investment was made in the Indian company by defendant number 12 to the tune of rupees 2 crores through payment instructions to Emirates Bank to debit the same, which was actually credited on July 1st, 2009. In 2011, 2 investments were made on December 26, 2011 to the tune of rupees 18 crores by payment instructions to Bank of Baroda, debiting the amount of defendant number 12 and crediting the account of the Indian company. Thereafter, share certificates in the names of the defendant numbers 3 and 4 were issued by the defendant number 1 around February 10, 2012. The plaintiffs also stated that defendant numbers 3 to 7 admitted and acknowledged that defendant number 2 had a beneficial interest in the share certificates of the India company issued in their names. Defendant numbers 3 to 7, however, do not have physical possession of these 2,70,000 shares, the same being held by defendant number 11. It was also contended in the plaint that defendant blank had share transfer forms of the company. Accordingly, it was urged that defendant number 2 has a beneficial interest over the share of defendant number 1 but held in the names of defendant numbers 3 to 7. It was further urged in the plaint that deconsolidation of the accounts and businesses of defendant number 2 with that of defendant number 11 was affected in 2016 with retrospective effect from 2014. The same was on account of defendant number 3, 4 and 7 to sign the financial statements of defendant number 2. It was also urged that till the time the Indian company had requirements for funds, the interest of dividend defendant number 2 was acknowledged and it was stopped subsequently. It was further urged that the entire remittance towards the suit shares of 6.16% of the Indian company were by the funds provided by defendant number 12 or defendant number 2 and no part of the funds came from the personal accounts of defendant numbers 3 to 7. It was further urged by the plaintiffs that defendant numbers 8 to 10 had direct knowledge of these facts. It is pertinent to mention here that there is no dispute regarding the fact that the decision of the board of directors of the group journal body followed by defendant number 11 through the draft financial statement would impact the beneficial interest of defendant number 2 in the shares held by in the name of defendant numbers 3 to 7, which was the subject matter of the suit. Plaintiff number 2 under these circumstances wrote the letter dated June 1, 2017 to defendant number 8, the managing director of the Indian company, protesting that the investments made by defendant number 2 were denied. Defendant number 1 through its letter dated June 7, 2017 refused to take notice of the claim asserted by the ETA group. Plaintiff number 2 thereafter sent another letter dated June 12, 2017 to the Indian company addressed to the managing director of the Indian company giving details in support of the claim of the ETA group. He also called for a meeting in person. However, defendant numbers 8 and 9 along with other directors of the Indian company failed to attend the meeting proposed by plaintiff number 2. However, they sent a letter dated June 27, 2017 stating that they had earlier replied on June 7, 2017 itself and had nothing further to state. Plaintiff number 2 sent another letter dated July 9, 2017 reiterating his original stand. The Indian company responded through the letter. Stop. Starting in 5 seconds. Honorable Speaker, Sir, due to the pandemic-induced closure of schools, our children, particularly in the rural areas and those from scheduled castes and scheduled tribes and other weaker sections, have lost almost 2 years of formal education. Mostly, these are children in government schools. We recognize the need of impart supplementary teaching and to build a resilient mechanism for education delivery. For this purpose, one class, one TV channel program of PM eVidya will be expanded from 12 to 200 TV channels. This will enable all states to provide supplementary education in regional languages for classes 1 to 12 in vocational courses to promote crucial critical thinking skills, to give space for creativity, 750 virtual labs in science and mathematics and 75 skilling e-labs for simulated learning environment will be set up in 2022-23. High quality e-content in all spoken languages will be developed for delivery via internet, mobile phones, TV and radio through digital teachers. A competitive mechanism for development of quality e-content by the teachers will be set up to empower and equip them with digital tools of teaching and facilitate better learning outcomes. A digital university will be established to provide access to students across the country for world class quality universal education with personalized learning experience at their doorsteps. This will be made available in different Indian languages and ICT formats. The university will be built on a networked hub spoke model with the hub building cutting edge ICT expertise. The best public universities and institutions in the country will collaborate as a network of hub spokes. An open platform for the national digital health ecosystem will be rolled out. It will consist of digital register of health providers and health facilities, unique health identity, consent framework, and universal access to health facilities. The pandemic has accentuated mental health problems in people of all ages. To better the access to quality mental health counseling and care services, a national tele-mental health program will be launched. This will include a network of 23 tele-mental health centers of excellence with NIMHANS being the nodal center and International Institute of National Technology, Bangalore providing technology support. Recognizing the importance of Nari Shakti of our government has comprehensively revamped the schemes of the Ministry of Women and Child Development, Government of India. In 2022-23, 80 lakhs houses will be completed for the identified eligible beneficiaries of PM Awas Yojana, both rural and urban. 48,000 crore is allocated for this purpose. The central government will work with the state governments for reduction of time required for all land and construction related approvals for promoting affordable housing for middle class and economical weaker sections in urban areas. We shall also work with the financial sector regulatories to expand access to capital along with reduction in cost of intermediation. A new scheme, Prime Minister's Development Initiative for Northeast, will be implemented through the Northeastern Council. It will fund infrastructure in the spirit of PM Gati Shakti and social development projects based on the needs of the Northeast. This will enable livelihood activities for youth and women, filling the gaps in various sectors. It will not be a substitute for existing central or state schemes, while the central ministers may also pause their candidate projects. Priority will be given to those paused by the states. An initial allocation of rupees 1500 crore will be made and the initial list of projects is given. Our vision to improve the quality of life of citizens in the most backward districts of the country through aspirational districts program has been translated into reality in a short span of time. 95% of those 112 districts have made significant progress in key sectors such as health, nutrition, financial inclusion, and basic infrastructure. They have surpassed the state average values. However, in those districts, some blocks continue to lag. In 2022-23, the program will focus on such blocks in those districts. Border villages will experience population limited connectivity and infrastructure often get left out from the development gains. Such villages on the northern border will be covered under the new Vibrant Villages program. The activities will include construction of village infrastructure, housing tourist centers, road connectivity, provisioning of decentralized renewable energy, direct to home access for Doordarshan and educational channels, and support for livelihood generation. Additional funding for these activities will be provided. Existing schemes will be converged. We will define their outcomes and monitor them on a constant basis. In 2022, 100% of 1.5 lakh post offices will come on the core banking system, enabling financial inclusion and access to accounts through net banking, mobile banking, ATMs, and also provide online transfer of funds between post office accounts and bank accounts. This will be helpful especially for farmers and senior citizens in rural areas, enabling interoperable and financial inclusion for all people of the country. Stop.